Thank you. We welcome you all to the Court of Appeals this morning. We have 4 matters for consideration on our docket, and 2 of those have been scheduled for oral argument. The first of those is Terry versus Terry, our case number 2023-1107. We'll go ahead and take appearances from counsel.
Michaela Irvin and Emily Adams on behalf of the appellant, Jamie Terry.
Thank you, Ms. Irvin.
And who will be arguing?
I will, Michaela Irvin.
Spencer Brown and Jennifer Falk on behalf of the appellee, and I'll be arguing.
Thank you, Mr. Brown. I think that you all know our standard procedure of 15 minutes aside. It looks like you've reserved 3 of those minutes, Ms. Irvin. If we're asking questions, of course, as time expires, we anticipate that we continue talking and getting through those questions. And so don't feel like you need to ask permission to answer questions, even if the clock's gone to 0. And if you don't have questions before we begin, then we'll go ahead and start.
Good morning, Your Honors. Jamie and Craig suffered significant injuries in a motorcycle accident, and as a result of those injuries, they received a $2.7 million insurance payout, $1.894 million of which was deposited into Jamie and Craig's marital account. The district court determined that the $1.894 million accounted solely for the parties' pain and suffering and was thus their separate property. Ultimately, the district court awarded Jamie just 16% of the overall $2.7 million. That was an abuse of discretion. First, the $2.7 million was commingled, and as a result of that commingling, it was marital property, subject to an equal, or at least a nearly equal split here. Shortly after Jamie filed her opening brief, this court issued Thorup v. Thorup. And in Thorup, this court clarified that commingling can arise in at least one of 2 situations. Under the first situation, one spouse has contributed separate property to the marital estate with the intent that it become joint property. The second situation, on the other hand, arises when the separate property-owning spouse has inextricably and untraceably intertwined that separate property with the marital estate. As Jamie argued before the district court, and as she demonstrated in her opening brief, both of those situations exist here.
Can I ask you a question? In your understanding of what the district court did, I'm not sure how to ask the question. What question was it that the district court was answering? Was the district court trying to decide what it thinks the parties intended in terms of the allocation between Jamie and Craig for pain and suffering? Or was the district court instead trying to decide what it thought a fair apportionment would have been?
It seems as though the district court determined that because the past medical expenses had been paid, and because there was no evidence as to future medical costs, originally the district court said the $1.894 million accounted for, therefore, pain and suffering.
Right.
But ultimately, the district court allocated the $2.7 million as though it accounted for.
Right. So when the district court comes up with the 84-16 split,
Yes.
It was a little bit unclear to me from the briefing. It may have been there, and I may have just missed it. But in your understanding of what the district court was doing at that moment, was the district court saying, "I think this is the percentage that those 2 thought was the right breakdown when they agreed to the settlement," or was the district court instead saying, "Based on my review of everything that happened to the 2 respectively, this is what I think would have been the fair apportionment, 84-16"? What question was the district court answering?
The district court was answering what allocation did Craig deserve based on the severity of his injuries, and what portion of the settlement did Jamie deserve based on the severity of her injuries. And the district court reached that question in the first place because it had first concluded that the $1.894 million accounted for solely separate property, pain and suffering. And so then it turned to allocate the division of that pain and suffering to Jamie and Craig.
I have a standard of review question.
Sure.
Thorup says that whether property is marital or separate is reviewed for abuse of discretion.
Yes, Your Honor.
But Brown and some other cases, but Brown is the one mentioned in the briefing, says that whether property is marital or separate is a question of law. What's your view of the standard of review? And I heard you say abuse of discretion, so I assume you're
I'm pulling from Thorup, Your Honor. So at the time that Jamie filed her opening brief, Thorup hadn't been issued. And at that point, there was, it seemed as though some conflicting case law from the Supreme Court as to what the standard of review would be ultimately when doing the classification question. And Thorup appears to have answered that question, that the standard of review there would be abuse of discretion.
And you'd say that Thorup answers it, even though that Thorup is a Court of Appeals opinion and resolves the Supreme Court indications the other way?
That's a fair point. At least before this court, it's an abuse of discretion under Thorup, but under either standard of review here, the district court got it wrong.
Did Thorpe really wrestle with the fact that we've talked out both sides of our mouth?
For the, I'm
Yeah,
sorry,
in
for the standard of review.
establishing, you say Thorpe answered the question. The question would be that we have been inconsistent in our articulation of the standard of review. Where do you read in Thorpe that Thorpe recognized that disparity and actively resolved it? Or did they just make a statement on what the standard of review was?
If I remember right, this court in Thorpe resolved perhaps some inconsistency within its own case law, and that it had spoken about.
Where?
You know, I don't have Thorup in front of me directly, but
The reason I ask is in two recent decisions by this court, both of which I authored, I dropped a footnote to point out this exact question, that we have, and in neither of those cases was it necessary to actually resolve the question. But both recently and in the past, we've stated both standards without really recognizing. And in fact, members of this court have sat on all of those panels. So on one panel, they're saying correctness, and on another panel, they're saying abuse of discretion. So I'm just wondering if Thorpe has the weight that you want to assign it. I think it needs to at least acknowledge that there's a split of authority internally and then attempt to resolve it. Otherwise, it's just one more grain of sand on a beach of confusion.
certainly, Your Honor. Our position would be that Thorup is the correct, voice is
I
the
get
correct.
that, but where do you point to that says they actually wrestled with the question of the inconsistency?
I don't have Thorup directly in front of me, but I'm happy with, as soon as I sit down to pull
Okay.
up Thorup, and if I'm not able to resolve it presently, I'm very happy to file a motion afterwards.
Okay, can I take you back to the, okay, let me take you back. The district court sees this 2.7 that drops down to 1.8, and the district court, as you just put it a few moments ago, conducts something of a fairness apportionment.
Yes, Your
And
Honor.
I'll just put a card on the table. That has some resonance for me in terms of what the district court can do in a case in which both sides are fairly severely injured, which I think is the case here. But what would happen if the facts had been a little bit different? What would happen if if everything else was equal about this case? Motorcycle accident, both people are involved, joint representation, attorney, all of it. But instead of your client having had cervical fusion and spinal injuries and injuries per foot, she just sprained her foot and was off it for a week. And everything else was equal. Joint representation goes into the joint marital account and so forth and so forth. What would you be arguing in that scenario? Would you still be arguing that she was entitled to 50% of that, or how would that play out in that scenario?
Under commingling, yes, Your Honor. So the argument there would be that commingling exists, and under the commingling framework, that this was marital property, and so we start at default presumption of a 50-50 split. And at that point, the district court can turn to exceptional circumstances and the equities and allocate for those.
So you would agree then, I don't want to put words in your mouth, but I want to make sure that I've got the framework right. So your argument there would be that there would be commingling, but in an extreme case, the district court could come in and adjust. Is that what you'd have to say, or would you have to say something different than that?
Sure, but even on these facts, even if we turn solely to the equities here, the district court's ultimate allocation was inequitable here. For example, in your hypothetical, that's addressed directly in the Phillips case, which we cite in our opening brief. And there, it was the same factual setup. The husband and wife were both injured in a car accident. The wife received a cut on her forehead and some bruises, and the husband, on the other hand, received really severe injuries. And the district court held that the pain and suffering, or rather the personal injury settlement, was marital property. But despite that conclusion, the husband was entitled to 90% because his injuries were so severe, and the wife was entitled to 10%. And she had received just a cut on her bruises or a cut on her forehead and some bruises. Here, I mean, Jamie is.
So analytically, the thing that's happening in that kind of case would be there's commingling initially, but then the district court can adjust under its discretionary authority? Or is it
Yes, Your
something else
Honor.
analytically?
Yes, Your Honor.
Okay, so here, this is where I think things get tricky for you, and I'm just not sure how tricky. To the extent that this is turning on an abuse of discretion standard of review, we've got a mountain of case law that comes up in all kinds of circumstances that talks about how hard it is to show an abuse of discretion. No reasonable jurist would have viewed things this way. So if the district court here looks at the respective injuries of the two parties, and in its view, its discretionary view thinks that the split is 84-16, walk me through how I'm going to get over, assuming it is an abuse of discretion. Walk me through how I get past that hurdle, because that seems to me to be the biggest problem from your end.
And to be clear, Your Honor, are we operating under the assumption that the district court has set aside the commingling decision and we're purely focused on the equities? Is that right?
However it is that we get to the equities, but how is this so far outside the court's discretionary authority that we get to overturn it based on our reassessment of the district court's own reassessment of what happened here?
Yes, Your Honor. So here the district court's findings itself found that when we consider the severity of Jamie's injuries compared to the severity of Craig's, we come up nearly equal. The district court acknowledged that Craig here had lost a limb, and that was a severe injury. But the district court also found that both Jamie and Craig had significant mental and physical pain, and that's on 807 of the record. The district court also found that Jamie and Craig had day-to-day limitations. In fact, the district court found that there were no significant differences in those limitations, and that's on page 808 of the record. And then here, based on Jamie's age, gender, and life expectancy, she was anticipated to suffer from her injuries for a longer period of time because she was expected to live longer than Craig. So based on the district court's own findings of the evidence, the district court's conclusion was improper here.
It's improper because it's unreasonable? It was just too extreme? Is that?
It wasn't supported by its findings or the evidence presented.
Suppose instead of splitting at 84-16, the district court had split at 60-40. What would you be arguing at that point?
I think we would be in a different circumstance. Again, the argument would be that we're trying to get as close to 50 as possible under commingling, and based on the intent and based on the intertwining between the separate property and the marital property, that deserves or warrants an equal, or at least a nearly equal split, but certainly a 60-40 would be a different question than an 87-13. An 87-13 is closer to the 90-10 split that we see in Phillips. And again, in Phillips, the wife there suffered from a scratch. Jamie, if we simply take a look at Jamie's injuries lined up against Craig, again, it's bordering on almost equal. Craig, he had whiplash, contusions, a cracked sacrum, a broken pelvis, and then a variety of broken bones that, of course, led to his amputation. But if we look at Jamie's injuries here, we have a neck fracture that resulted in a lack of mobility to her neck, and she had immediate surgeries on her neck. She broke her pelvis, she fractured her fibula, she had some minor head trauma, and she broke all of the bones in her foot, including her ankle, her heel, and her big toe. As a result of those injuries, she lost mobility in her foot. She's characterized her foot as clawed and deformed. So if we line up Craig's injuries compared to Jamie's injuries here, we're vastly different than the injuries or the comparison of the injuries in Phillips. So therefore, based on those pieces, that evidence there, the district court's ultimate allocation, regardless of its discretion here, was improper.
You mentioned that in Thorup, that there were two ways to come to a conclusion of commingling, and one was intent of the parties and one was intertwining.
Yes,
On
Your
the
Honor.
intertwining, do I correctly understand, and I very well may not, but is that the idea that the funds become untraceable to where we can't figure out what went where? Is that the intertwining that we're talking about?
Yes, Your Honor. I'm thinking of language in Kimball specifically where the separate property, its identity has become lost. It's been consumed by the marital estate.
And here it seems like the funds can be traced. We see a deposit coming in, we see half of it going over here and half of it going over here. You suggested that the standard is met under either. How were the funds so intertwined and commingled that we can't trace them?
That intertwining occurred long before Jamie and Craig ever deposited that $1.894 million into their joint bank account. And let me see if I can back up and explain that here. Craig bore the burden of demonstrating that the $2.7 million accounted solely for pain and suffering, that it was simply separate property. Craig failed to meet that burden here. He failed to put forth any evidence as to what American Family or Farmers Insurance was thinking about when they compensated Jamie and Craig for their injuries. And to the contrary here, Craig's own expert testified that when an insurance company sits down and considers a claim, they consider all damages. That's language directly from his expert on page 1576 of the record. This includes past medical bills, it includes past wage loss, which we know under Anderson and Naranjo are marital property.
So your argument is that before the settlement check was ever issued, it had been commingled.
When it was issued and when the insurers issued those funds to Jamie, Craig, and their attorney collectively without any distinction or breakdown of that $2.7 million, that's when the commingling occurred. That's when we lost the share of the settlement that was intended to compensate Craig for his pain and suffering. We lost that amount with the amount of the $2.7 million that was intended to compensate Jamie and Craig for their past medical expenses.
How do we distinguish that analysis from an intent analysis? Or here, do they just kind of overlap each other?
My reading of Thorup is that we have two pathways to commingling, and that the first situation, which this court described as the most obvious, is intent. Do we have intent here that demonstrates that Jamie and Craig desire to treat these funds as joint property? And we certainly have that here. But even short of that, and that's the language this court uses in Thorup, even short of an outright contribution, where intertwining exists, commingling exists as well.
And it seems like the thing that you're going to point to for intent happened, well, maybe you're pointing to multiple things. Some of what you're pointing to is what happened after the check was issued, that they each
Yes,
withdrew half. But that some of the evidence that you point us to for intent are the things that happened before the check issued? Are there things that happened before the check issued that would point to intent?
Sure. Specifically, Craig and Jamie deliberately hired the same attorney here, and they did so for a practical reason. The attorney was Jamie's nephew, and he offered them a significant discount on his legal fees. So they they took on the same legal representation. That attorney filed the same claim. There was no discussion about distinction or discrimination between Jamie's share from Craig's share. There was no objection by Craig. But the most weighty actions that Craig and Jamie took here are the actions that they took at or around the time that the funds were dispersed. Specifically, Jamie and Craig each signed the same release statement, which stated that it was resolving both Jamie and Craig's claims in exchange for the $2.7 million. And then when Jamie and Craig received these 5 checks addressed to both of them, they authorized their attorney to deposit those funds into their joint marital bank account, where they sat for about a month. Most tellingly here, Jamie and Craig then turned around and met with the same financial advisors, seeking the same advice on how best to jointly invest these funds to set themselves up for retirement. And when they couldn't agree, Jamie withdrew half of these funds. Craig did not object. Instead, he withdrew the remaining half, and then after those withdrawals, Jamie and Craig then contributed the same amount from that $1.894 million that they had split towards the same joint marital purpose, paying off the mortgage on the home in which they lived, in which Craig had a share at the time. And if there's ultimately any question about Craig's actions and how Craig viewed the $1.894 million or the $2.7 million more globally, that question is answered by Craig himself in his original divorce petition. And I'm reading from page 5 of the record. There, Craig states, "The parties recently suffered a terrible accident where they were both injured. The settlement monies have been partially paid, and the parties have equally divided said funds. Any remaining funds should also be equally divided." Craig maintained that position for the following 18 months. Based on the actions that he had taken before the settlement funds were dispersed, at the time that they were dispersed, and after they were dispersed, until he later filed his motion to amend, those actions as a whole, and that's language pulled from Kimball, manifest a clear intent to treat the funds as joint property.
Thank you.
Can I ask a question?
Of course.
On page 5, at the top of your principal brief, you outline the various policies that paid. And I believe somewhere in your brief, and I was trying to find it this morning, it indicated that part of the evidence, I think, and this is what I'm going to ask you about, was the declaration sheets from these policies. Were those declaration sheets in evidence?
You know, Your Honor, I don't know the answer to that question.
Okay, I want you to assume for a moment that they were, and that your graph on page 5 of your brief is showing the separate policy amounts, except for the umbrella policy of $2 million. Those other amounts would have been per person, right? So those were actually allocated by the policies. You understand policies typically have limits for per person and per accident. So as to each of them, $350,000 wasn't really jointly paid. It was per person. So the initial $100,000 on each of them and the next $250,000 on each of them, the policies themselves were paying by the person, weren't they? Is that accurate?
Yes.
Okay.
The wrinkle here is that Craig sought a portion of the entire $2.7 million, specifically an 87-13 split, which is what was in his trial brief. Because Craig requested that portion, he bore the burden of demonstrating that each of those pieces accounted solely for pain and suffering, and that he was therefore entitled to a larger share due to the severity of his injuries. And Craig failed to meet that burden here. And because of that failure, those funds have been commingled, treated as marital property, regardless of whether Farmers Insurance doled out a check to Craig and Jamie. And in fact, each of the 5 checks were addressed to Jamie, Craig, and their attorney collectively. It wasn't a situation where Farmers had dispersed a check to Jamie for $100,000. I see that I'm out of time, and unless there are any further questions, I'll go ahead and conclude if that's okay.
Yes, thank you. And since we kept you over, you'll have your full time on rebuttal.
Okay, thank you very much.
Thank you, Ms. Irving.
So for the reasons that we discussed, the district court got it wrong here when it held that the $2.7 million hadn't been commingled. Because of that error, the $2.7 million was marital property subject to an equal or nearly equal split. But even if this court is ill-inclined to find that commingling exists here, the district court nonetheless got it wrong when it calculated Jamie just 16% of the overall 2.7. This court should therefore reverse. Thank you.
Thank you. Mr. Brown.
Good morning, Your Honors, and may it please the court. The district court did not abuse its discretion when it ruled that the proceeds of Craig and Jamie Terry's personal injury settlement were not inextricably and untraceably intertwined.
Can I start off with the same question that I led with opposing counsel on? When the district court makes this 87-13 split, in terms of what it was that the district court thought it was doing, was it making an allocation based on what it thought the party's intent was in terms of splitting it? Or was it making an allocation based on what it thought was fair and equitable under the circumstances?
What the district court was doing, Your Honor, is it was making an allocation of what it thought was fair. It was applying the model Utah jury instruction for personal injury damages to determine how this award should have been split.
I'm struggling conceptually with how that's even possible. And let me tell you why, and then just get your reaction to it. This case doesn't go to a jury. It's done by settlement. We don't have anything like a special verdict form where, if this had gone to a jury and the jury could have allocated it based on whatever boxes were given to it. Who knows what goes into the sort of mix that goes into a settlement? This isn't even the personal injury case itself. This is another case. This is a divorce case. So you've got a district court in a second case retroactively assessing what it thinks would have been fair in a different case that resulted in a settlement where we don't have boxes that anybody checked. I'm not sure how a district court is supposed to go in and reverse engineer this and figure out for itself what percentage went to whom and for why. I'm not sure analytically what the district court, what gives it the ability to do that.
Right, Your Honor, and the district court, I agree, was put into a difficult situation here. The reason why it found itself in this situation is, of course, because in reaching this settlement, of course, it was a policy limit settlement. There wasn't much negotiation to this settlement. There wasn't an allocation made between Craig and Jamie Terry. But we know from the case law that because these damages went to pain and suffering, which is a separate claim, which is separate property when these folks split up
Right.
a short time after the accident, that there has to be an allocation made.
But there's no, I mean, you've given us the factors and you've pointed to the Muji factors for pain and suffering, but there's no math to that list of factors. In an ordinary case, it goes to a jury.
Right.
The jury sort of puts it in a pot and comes up with a number, and then we tend to give heavy deference to the number, I think precisely because it's so fuzzy.
Right.
And so how do you, if it's fuzzy to the jury that gets it in a personal injury case, how does some other court in some other case come in and pretend that there's math involved? I don't understand this.
And so that's exactly the question is what do we do on the back end when there hasn't been a jury, but now there has to be a split between these people? And there is heavy deference to the trial court here. We're looking at this at the minimum from an abuse of discretion, and then for the court's factual findings for clear error. From the factual findings, the court says, okay, I have to look at this. I know this is separate property, and I have to come up with a reasonable way to divide these proceeds. And I know it isn't 50-50.
But wouldn't the reasonable way, given that we're dealing with a settlement, wouldn't the reasonable way have to hinge on this is what the parties intended when they agreed to sign the settlement agreement?
Perhaps, but
How could it be anything other than that?
well, because I don't think that the folks, I don't think that the parties in this case came to any agreement as to how they believed that this would split up.
So then, if they're not agreeing, I'm having similar thoughts to, I was gonna call you president.
I mean, I won't say no, but
Judge Tenney down there, you're saying two things. Number one, you're saying the parties didn't have an exact idea. They didn't have an understanding of what this was. They put it in a joint account. And at the time they put it into a joint account, you're saying it's separate, but we don't know what amount is separate. And that seems to rub right up against this idea that it's easily traceable. Because at least for a minute, until on the very back end, we have some district court judge quantify now what its separateness is at the moment it hits this joint account. And you're saying it's separate, but we don't know how much of it is separate. Is that really traceable in kind of the Thorup idea of traceable?
Well, I think it still is, Your Honor. We know exactly where all of these funds came from. We know where they were when they came in. We know.
This traceability thing that we've established, it's like many things that we establish, they sound great, but they're kind of weird. And traceability to me is a little bit weird because there's these guys, they're called accountants, right? They can trace anything. And so really, it doesn't matter how convoluted any factual situation is when it comes to fungible dollars. There is some accountant back somewhere who can do me a spreadsheet and show me exactly to the beginning of time what happened to every dollar, and they say, see, it's traceable. And I don't think that's what the case law is talking about. I think it has to be basically earmarked. The classic example is we sell a house, the house has a certain market value, we deposit that money and we take it right out. Everybody knows that's what it was. But at least in that, when it comes in, we're like, well, that's what the house is worth. In this, when it hits the account, nobody knows what the respective claim values really are. Isn't that true, until the court puts a number at the very end?
Well, I think that there's, at the time that the amount hits the account, there's a disagreement as to what the respective claim value.
Wouldn't that lean in favor of finding it commingled then?
I don't think so, Your Honor, because Jamie, at that point in time, remember, she withdrew 50%, and she treated that as her property, as her portion, and Craig could do whatever he wanted with his portion. That's how she characterized it through the trial. That's not commingling, that's separate property, and that's the language of separate property. That's
Seems like
hers
that's
and
a-
mine.
Isn't
Sorry,
that
can I ask just one?
Oh, yeah.
Sure.
Maybe she, why isn't it equally valid that she took 50% of it because she thought it was commingled? In other words, if it's commingled, I'm entitled to 50%. I'm taking my 50%, not because it's separate, but specifically because it is commingled. Why isn't that right?
That strikes me as not the way the marital property works. Marital property is not his and hers. Marital property is ours. Marital property is in that joint bank account and is
But
the
everybody,
property that we.
the general person walking down the street when they get divorced thinks we're gonna split this and probably 50-50. And so if they own equity in a house, why is it a stretch to think that they're gonna think they're entitled to 50% of it? I just don't understand why her taking half the money necessarily is an indicia of separateness as opposed to I'm just entitled to that half.
Well, I think that would be right when they get divorced, but remember, her pulling the property from the account was long before they get divorced. It was months before Craig petitioned for divorce.
A month, right? Or no?
I think it was multiple months before.
I thought it was 1 month after the settlement checks hit.
Yes, it was 1 month after the settlement checks hit, and it was about 3 months before Craig petitioned for
Right.
divorce. So it was before divorce ever became an issue, and she treated this as separate property. I'm gonna do what I want with my half, you do what you want with your half, with your portion. However, she testified at trial, and at times she testified about her half, times she testified
But
about
so,
her portion.
now we're back. I feel like Judge Mortensen and I are asking parallel questions in some sense, and in some sense they're sort of at different pieces of this. But I'm really stuck on the fact that this is a settlement and not a jury verdict. And so who knows what goes into the intent when you agree to the settlement? And if this whole question is turning on what the two of them intended the allocation of the 2.7 to be for each of their shares of the pain and suffering, because pain and suffering is so sort of fuzzy, maybe they thought it was 50-50, maybe they thought it was 60-40, maybe they thought it was 70-30. I mean, the two briefs have given us different accounts of the sets of injuries. I've kicked it around, I've run up on my clerks, and we've tried to figure out like which was worse and by what percentage. And I've come up with different numbers at different times I've thought of it. And so for precisely that reason, I'm struggling with the idea that somebody else could look back at this a couple of years later and say, oh, that was the percentage that they intended to go to his pain and suffering versus hers. If you don't have the two of them saying on the record, oh, when we agreed to sign that this is what we were thinking. We thought it was 60-40, we thought it was 80, whatever. That's what I'm struggling with, is how to reverse engineer a pain and suffering allocation on a settlement where we have nothing that we can point. I don't see anything that I'm being pointed to that I can point to that says that's what they thought when they signed the dotted line.
Yeah, Judge Tenney, I completely understand where you're going with this, and I think you're right, that in the record, there isn't agreement between the parties. Jamie, by her actions and by her testimony, indicated that she believed she was entitled to half. Craig, by his testimony, indicated he didn't think that that was fair at all. And so that's why the district court did what it did, why she said, look, there was no agreement here. And so I've got to find a way to allocate this. And that's why the district court had a trial, why the district court took testimony, and why the district court determined what the allocation of injuries were based on the Muji factors, based on what the testimony bear out as to whose injuries were worse, whose pain and suffering was
But even
worse.
within the context of the Muji factors, don't I have it right that a jury could take one factor and say that's the factor that matters despite all the rest of them?
A jury certainly could, and the district court, acting as the finder of fact in this case, could and did as well. And that's why this court, acting in review, gives heavy deference to the district court's findings of fact. And those findings of fact.
But given that the parties, sorry to cut you off, but
That's
given that the parties were married at the time that they settled, wouldn't it have been possible, I mean, I'm about to ask the sort of extreme hypo, go with it. Wouldn't it have been possible for the parties to say, oh, we think it's 80-20 her, not him? I mean, couldn't they, between themselves, have made that agreement?
I suppose it's possible. There's nothing
And they
in the
could have done
record
the
that
opposite.
suggests
They-
that
They
here.
could have thought it was 80-20 him. They're sitting around in the living room and they're comparing, battle wounds from this thing, and who knows how they valued it? But couldn't they have valued it any number of ways between them?
They could have, but on the record before us and on the trial testimony before us, there was no agreement between the parties as to how they valued it. What is on the record are the facts, and the facts that the district court found compelling is that Mr. Terry doesn't have a leg. That pushed her over the edge, that his injuries are different in severity, different in kind, different in quantum than Mrs. Terry's, right? At the end of the day, Mr. Terry doesn't have a leg, and that pushed her to say, all right, this is 83% his, 16% hers, or 83 and change his, 16 and change hers, right? That is a finding of fact that this court should give heavy deference to, because the district court, again, was sitting there as the trier of fact.
And the finding of fact that you're asking us to give deference to is that he doesn't have a leg, or it's more, what's the more?
No, it's the testimony at trial that gave Rose to his pain and suffering is greater than hers. His injuries are as such to merit a greater portion of this settlement agreement than hers. It's all of the testimony combined, that his future quality of life, everything else that the district court put into her findings of fact. And she laid it all out in her order as far as the detailed findings of fact, right?
You're characterizing the percentage split as a finding of fact. Is that correct?
Yes.
That you suffered, your suffering is worth 16% of this, your suffering is worth 84% of this. You're characterizing that as a finding of fact. that
Yes, and I think
deserves
that's
deference.
I think that's the correct way to look at it.
There's a preliminary determination that money was only for pain and suffering. Is that determination a factual finding, or is that determination a legal finding? And if it's so the two-part question, factual or legal, and if it's factual, what evidence did the court have to look at to say this settlement value did not include anything other than pain and suffering?
Your Honor, that's also a factual finding. That should be reviewed for clear error. And there was ample evidence on the record for the court to reach that finding as well. The evidence was, there were several pieces of evidence. First of all, there was Craig's testimony, one about his significant pain and suffering after the accident, and two, about the fact that he was not making a wage loss claim. He was placed on disability by his employer. He was receiving disability benefits. Second, there was Jamie's testimony about her significant pain and suffering and the effects on her life. Then there was a lack of evidence from her about any wage loss claim from her. Throughout the marriage, she was not working. She was not working as a registered nurse. She was working part-time at a friend's boutique. And she didn't put on any evidence of any type of wage loss claim, any type of
And when you say put on evidence, you mean in the divorce trial?
in the divorce trial, correct. She also didn't provide evidence, and we'll get to this in a minute because this is another thing, but she didn't provide evidence to the insurers as part of the settlement negotiations. She also didn't put on evidence of the amounts of the cost of her surgeries. Both she and Craig testified that they had additional surgeries after the settlement, but Jamie testified that from her memory that the surgeries were a certain amount, I think $35,000. She didn't put on any evidence of the cost of those surgeries, right? And I think they were maybe $35,000. When you're asking for credit for future medical bills, that's not evidence that cuts it at trial. Next, we turn to Craig's expert, and he testified that based on the documents that were before him, the documents that were submitted to the insurer, he can determine that there was any part of the settlement that went to anything other than past medical bills and pain and suffering. And that's on page 1567 of the record. It's true that the expert testified that insurers consider all damages and that they consider future medical bills, future lost wages, but they can only consider what's available to them. And here there was no evidence of future damages. And then you turn to the file itself, and what was provided to the insurers here were the Terry's past medical bills, the medical bills they'd already incurred, and then the severity of their injuries. And the severity of those injuries, particularly Craig Terry's amputation, was enough to push this well over the edge of a policy limit settlement agreement, and that's ultimately what they had. This settlement was reached in relatively short order, and everybody signed off, and that's what there was.
Where we're down to zeros, unless my colleagues have
I just have
questions.
one
I've got one as well, but maybe it would be best for last. It's about the standard of review, that you're also assuming
Yes.
an abuse of discretion standard. I assume you recognize I'd like Judge Mortensen's quote, "one more grain of sand on a beach of confusion," that we have a beach of confusion regarding this standard of review. You're content with it being abuse of discretion, or are you definitive that that's what it's got to be?
In general, Your Honor, I think that there are some factual issues where this needs to be reviewed by clear error, and I think I've highlighted them. I did have the benefit that my colleague didn't while she was being questioned here of looking at Thorpe. What it seems to me, Thorpe, to answer Judge Mortensen's question from earlier, it doesn't directly grapple with the inconsistent standards from this court. But it does highlight and seems to rely on Dahl from the Supreme Court, which is clear in its standard of review for commingling and the other issues that it is an abuse of discretion standard. My feeling on that is that this court should follow the Supreme Court and should follow the direction from Dahl and review for abuse of discretion. I totally understand that there's confusion in that, but that's how I read Thorpe, is that it was adopting the Dahl standard and falling in line with that, and I don't know what other way to read it, but do understand the confusion.
Did either party testify that on the day the check was deposited into their joint account, that they had an understanding or an intent of a specific dollar amount that was theirs? Do you understand my question?
Neither party testified that they believed that on that day.
Okay. Thank you.
Thank you, Your Honor.
Thank you, Mr. Brown. Irvin, excuse me.
Okay, Your Honors, just 2 points here. First, on the standard of review, we acknowledge that it's unclear here, but ultimately under Krasinski, the approach of this court has been to analyze under either standard to determine if the district court nonetheless got it wrong. And here, the district court got it wrong under either standard. And if this court we're happy to do supplemental briefing on the standard of review issue as well and submit that. On my second point here, as far as what the district court did do here, I'd start first with what it didn't do. The district court didn't consider intent here, and it should have. That was argued before the district court by Jamie's attorney. It didn't consider intent. And instead, the district court simply determined that they placed the funds into the joint bank account and then withdrew halves of that $1.894 million, and that wasn't enough to equate commingling. But as you pointed out, Judge Tenney, what matters here under Dahl and under Kimball is what Jamie and Craig thought when they signed the dotted line.
So this leads to the question that I wanted to ask in your rebuttal, but I wanted to make sure I didn't hijack your rebuttal, but I think you've led me to it, so here we go.
Okay.
What happens if you win? And let me go ahead and ask you the full version of the question, but that's where I'm going with this. What happens if you win? So I think what you want us to say is you want us to say that it was commingled when the funds got into the account. And suppose we agree with you on that, and I look back at the remedy sought, and you've asked us to reverse the district court's award. So if we say to the district court, no, you got it wrong, it was commingled. As I understand it, even if the court is forced to conclude that it was commingled, the court at the back end can still exercise some discretion and divvy things up. Do I have that right?
Yes, the district court has to make findings with regards to exceptional circumstances in order to
Okay,
deviate.
so if the district court still has that authority on remand, we have a pretty fair idea of what the district court thinks the fair allocation here is. The district court thinks it's 87-13. So I don't know what are we just gonna get to the same place at the back end? The district court would then say, okay, it was commingled. But I think in the exercise of my equitable authority, this really should be 87-13 because he lost a leg. So are we gonna end up in the same place we are, just under a different step? And does that matter?
The district court didn't make findings with regards to exceptional circumstances, and it needed to, assuming it had made the conclusion that commingling existed here. But even without those findings from the district court, this court has enough here to conclude that the 87-13 was inequitable based on the district court's own findings and the evidence that was presented at trial.
So I guess the more pointed version of my question now that I'm thinking of that is, are you asking us to send it back to the district court with instructions to split it 50-50? Or are you asking us to just reverse the commingling and then let the chips fall where they may once the parties find it out a little bit more?
To reverse on the commingling decision and instruct for an equal or at least a nearly equal split in acknowledgement of that intent.
But as you point out, there weren't any findings as to exceptional circumstances, so shouldn't we give the trial court the first bite at that issue?
Perhaps, Your Honor.
By saying that it was commingled at the time the check issued, we don't even get to the commingling question unless we have separate property to begin with. That it's when you have separate property that then you analyze whether it's commingled. By saying it was commingled when the checks issued, are you conceding that this was separate, that it was for pain and suffering only? And
Some
therefore
portion of the $2.7 million was intended to compensate Jamie for her pain and suffering, and some portion was intended to compensate Craig for his pain and suffering. Yes.
Are you contesting that any part of it was for his lost wages?
For his past lost wages or his future lost wages?
Either?
If they're past lost wages, that's marital property, and the amount that are intended to compensate either Jamie or Craig for their past lost wages should be split down the middle as marital property.
And I understand that principle. I'm asking, are you contesting that the settlement proceeds were in part, notwithstanding his disability claim, to cover marital things like past and future wages?
Ultimately, Your Honor, Craig is and was required to answer that question, and he failed to do so. It was his duty to put forth evidence as to what American
That's
Family and Farmers Insurance were thinking about when they compensated Jamie and Craig, and he failed to do that.
Okay.
And unless there are any further questions, we ask this court to reverse the district court. Thank you very much.
Thank you both. We appreciate your briefing and your oral argument. It's been helpful today, and we will take the matter under advisement and get you an opinion as soon as we are able.